Good morning, everyone. Good morning, Madanji. Let me just welcome you
Morning.
to the show. We have Madan M. Gakhar with us. He is a family lawyer with close to 10 years of experience, and he is going to be answering some very important questions today. Welcome to the show, Madan.
Thank you.
So, for our viewers, we would like to know, first of all, what is a will?
So it's a document which everyone should have, and this deals with your assets after you die. So basically, if you don't have a proper will in place at the time of your death, then your assets, I mean, there is going to be dispute about your assets, and
Mm-hmm.
it may be dispute between the family members, or you may have to fight with the government who should get what.
Mm-hmm.
And basically, if a person has worked hard for his entire life, he would like to see that his assets go to his legal heirs after his death. He doesn't want to see the assets going to legal cost or basically left behind without being properly taken care of. So it is very important document which everyone should have. And under this COVID situation, I was basically going to promote, but I did not promote this because I didn't want to make it look like that I am taking advantage of the situation, because people may think that I am promoting the business. But my recommendation is everyone should have their will.
Thank you so much. This is very, very important point. We leave things like doing the will to the last minute, or if we fall terminally sick, that's when we start thinking of it. But I think your point is that we should start thinking of it as soon as we start creating assets.
Yes. And
Because
if
yes,
there are minor children involved, it's all the more important because, I mean, parents have to think that, I mean, how are the children going to be taken care of in case they die?
true. True, true. A very serious and a very pertinent topic, especially in our Southeast Asian community, because when we arrive in Canada, we are more focused on settling down and making things work for us, and we forget this very important aspect. So, thank you very much. Um, is it possible that a will also be used while a person is still alive?
So that's not called will. The technical meaning of will is it becomes effective after the death of the person. So for a person who is alive, basically this is one of those situations where a person is lying in the hospital, unconscious, unable to take decision because of the mental state or because of the vegetable state he is in the hospital.
Mm-hmm.
So for that, we have enduring power of attorney. That's not called will. I mean, people say it's a living will, but it's enduring power of attorney. The correct word for this particular document is enduring power of attorney and personal directive. Enduring power of attorney deals with the assets. So basically, what this means is, in case you are in a situation in a hospital whereby you cannot take decisions, someone outside who is of sound mind, who is whom you trust, can take decisions on your behalf. So
I see.
that's the work an enduring power of attorney does. And enduring power of attorney deals with the assets only. And personal directive is the third document which we prepare with the will. Personal directive means when you are in a vegetable state in the hospital, someone and a major surgery needs to be performed on you.
Mm-hmm.
Someone
Mm-hmm.
has to decide for that. And generally, the doctors don't perform the surgery because they don't have personal directive in place. So it's very important that you should have personal directive in place, because in case something like this happens, you need someone outside who can make decisions on your behalf. And in my experience, we have used enduring power of attorney also.
Mm-hmm.
Somebody's father was terminally ill and he was in the hospital. In my experience, we have used personal directive also. And basically, I mean, the father was very sick and the daughter was the EPA for, it's called enduring power of attorney, EPA for the
Right.
father, and she made all the decisions. So
Right.
these are not documents, I mean, which you can say that without any use, they are useful. In case something happens to you, in case you meet with an accident, or in case, you know, any
Mm-hmm.
injury.
Right. So one of the questions that's coming to my mind, because I know a family where the husband has been in dementia state for like last 8 years, and they have been in a care home. In
Yeah.
such a case, is the same thing that you just spoke about, the enduring power of attorney, will that apply?
Yes, the personal directive will take care of his personal decision to his person. Basically, where he's going to
Okay.
live, what
Okay.
medicine needs to be given to him, what treatment needs to be given to him. So that's the work of a personal directive. And other than person, we have assets also outside. We
Right.
have house, we have cars, we have
Yes.
all businesses, right? That
Right.
that's basically enduring power of attorney. And it's not necessary that the same person should be basically deciding for your person, and the same person should be deciding for your assets also,
Okay.
because there are certain children, I mean, in the same family who take care of the parents more. They
Yes.
can be appointed as personal directive. And there
Right.
are there are children who are business smart, or who are smarter than the other children, who can take care of the business or assets properly.
I
So
see.
so you can have different people for different documents. And the bottom line for any kind of document is trust. You have to trust that person, that he's not going to basically make a decision which will be against my interest, and he's not going to make any decision which will affect me in the business also. So
Hmm.
so if you don't have trust on the person, then don't name that person in the enduring power of attorney or personal directive, because that means you're setting up that person for future litigation.
Absolutely. And one more question that is coming to my mind is that, suppose between husband and wife, like the husband in this case, when I was referring to a family that I know went into a dementia state and he had to be moved into the care home, is it the wife who automatically gets to decide, because this person cannot decide who he trusts, who he can recognize? Or is it the daughter? Like, is it the blood relatives? How is that distinguished?
So depends, because if there is a proper document in place, then the person who is named in the document will decide. If there is
Okay.
no proper document in place, then there may be certain documents which says emergency contact, or contact this person at this number,
Right.
then that person may replace. And generally, it's the wife.
Okay, thank you so much. That's very, very important to know as well. Or it could be an adult person in the family, like a child or a son or a daughter or something like that, if the
Yep.
mother herself is not in such a state that she can take the call, right?
Yep.
So that's very good to know. Just something that was coming to my mind while I was looking up what's available in terms of these documents that you have just spoken about. There are some standard kits available in the market. Can one just use those kits and create these documents, or going through a lawyer makes more sense? And why should one go through a lawyer if they have to?
So my answer to that is better something than nothing.
Mm-hmm.
So you should have something in place than nothing in place. So basically, if you're using the kit, it's
Mm-hmm.
called holograph will. Holograph will means a will which you have created with your own hands, or that's
Oh,
equally valid as a will created by a lawyer.
okay.
So holograph will is the will which you write with your own hands. That
I
is
see.
perfectly valid. A will that is created by the kit, all you need is two witnesses.
Mm-hmm.
That's also perfectly fine. But there are certain people who says we want to do it properly and we want to go through lawyer. Sure, but again, the legal profession in this country is the most costly profession.
Mm-hmm.
We are the most paid people
Mm-hmm.
in the country.
So then that,
So
sorry.
so if you go through a lawyer, I mean, you should have a budget of around $850 to $900 to pay a lawyer to prepare all three documents. But the only peace of mind you will have is that it's created by a lawyer. The chances of having any kind of deficiency are very minimal. And if you create on your own, sure, you can create on your own. I do get calls from people who says they want to notarize a will,
Mm-hmm.
and have created the will we have written based on the kit that was available, and we want a lawyer to notarize the will. I don't do that. because
Mhm.
the moment I put my signature on a will, that means I have given some kind of advice to that person, and then
Mm.
my insurance comes in. Basically, it's my liability that I did everything properly.
Mhm.
So there are people who do that, but I don't. So I either do my own and basically ask the client to sign that, or I
Mhm.
don't.
Oh, thank you so much. You actually answered one of my questions, which was going to be what does it cost to get the services of the lawyer from starting to
Yeah.
the end. So it, like you said, it's like 850 to $900. And is there a cost associated with executing the will after the person passes away?
So that's called probate. That's
Mm-hmm.
called you have to get a letter of grant of probate from the courthouse. So I'll have to explain the will first in order to answer this question. So
Okay.
in a will, you appoint a person as your personal representative.
Mm-hmm.
And personal previously the term used was executor.
Mm-hmm.
So the executor was the person who executes your will.
Right.
Now they have changed the term in 2013, I believe. They changed the term to personal representative. And personal representative is the person who takes care of all your assets as per your will. Whatever you wrote in the will, he has to do exactly as it is.
Mm-hmm.
And in order to do that, he needs a court order.
Oh, I
So
see.
there's a will in place, a document which says that I appoint X as my personal representative, and he gives all the powers. He tells this is what you need to do after I die, and now the personal representative has to basically do as per the wishes of the deceased person.
I see.
So he will apply to the court for an order saying that please, according to
Uh,
this, I should be appointed as the personal representative. I need a court order to deal with his bank account, to deal with his assets,
Personal
to
assets. Yeah.
everything. And that's an application for grant of probate, which we
Okay.
do after a person die.
Mm-hmm.
And normally the processing time of this application is between 12 to 16 weeks under
Okay.
the current circumstances.
Okay.
So within 16 weeks, let's say, or within 12 weeks, the person will have the powers to deal with all the assets of the person.
Right. Okay. So these are some very, very important things to know, and you actually help the person to create that application that will be taken to the court for that probate orders, right? And
Yes.
then this person who has been appointed as the executor, or now known as the personal representative,
Yeah.
is then able to carry out the will. And at that point, does your services end, or do you have to be there as a lawyer?
Once we have given the letter of grant of probate,
Ji.
that's the end of the matter because the deceased person trusted a personal
Yes.
representative.
Yes.
Now it's personal representative's responsibility to basically honor that trust and do according to the will. Do everything according to the will. That's it. My work ends when I give that letter to the person.
And may I ask, one related question is, what is the cost of getting your services for that application for probate?
Depends whether it's contested or uncontested. Normally it's uncontested. If a will is created, then there is
Mm-hmm.
no one to fight because the deceased person prepared the will according to. That's why we need to have a lawyer, because if it becomes a contested
Mm-hmm.
will, a
Mm-hmm.
lawyer can go into the court and testify that yes, it was signed before me, these were the questions I asked, he was of sound mind, he told me this is what I want to do,
Mm-hmm.
and I prepared the will accordingly.
Right.
So chances of lawyer's testimony being upheld in the court are super high.
True.
So if it is uncontested, so basically whereby people say that, yes, the will was created, he was appointed, and it's uncontested, the fees is
Mm-hmm.
not too high.
Mm.
And if it is contested, then the lawyer's hourly rate kicks in. So
Ah,
I have seen lawyers charging, let's say, $500 an hour. I have
right.
seen lawyers charging $750 an hour. So
Yeah.
whatever the person who created this estate, half of the estate goes to the lawyer in the fees or, you know, disburse.
Totally. I hear you. Yeah, yeah. And that brings me to a very important question that's related to the community that we are serving. So, for our Southeast Asian community members, is there a recommendation you have on how to go about it? Like, what is the best case? Like, what's the best approach to get this done?
So in our community, the biggest issue I have seen is the fees part.
I see.
Because the moment lawyer says that it's going to cost 700, $800, they say,
True.
we don't want to do it.
Hmm.
So I have had files in my last, I would say, 7 to 8 years, whereby the parents died without having a proper will in place.
Oh my God. Okay.
In that case, what in few files, basically the children agreed, saying that eldest son of the family will be appointed as the personal representative. We will
Hmm.
leave it up to the eldest son. They decide between themselves, saying that what, we all will divide equally. Let's not
Hmm.
fight. Let's not pay to the lawyer.
Hmm.
Something like this happens, then it's a very good approach, because you are spending small amount of money to get one person appointed, and they have an agreement in place between themselves, saying that what, we'll sell off everything and we'll divide everything in equal parts.
Hmm.
So this was one approach. Second approach was whereby, I mean, the person initially agreed to saying that what, my brother can take care of this, and you know we'll we'll decide between ourselves
Right.
what to do with the assets.
Right.
And then subsequently there was a dispute between the brothers,
Hmm.
and by that time you enter into litigation, you start fighting over the same money which is lying in the pot, and you end
Hmm.
up spending thousands of dollars
To the lawyer.
on lawyers
True.
to get that piece of pie.
Right. Unless
Yeah.
it runs into millions or billions, there's no point in getting going down that path, is what I'm hearing.
Yes, in our community we have only, I would say, 5 to 10% people who have millions and billions.
Right.
Most of the people are middle class, and middle
Hmm.
class have a lot of money.
Right. So then it is very, very important that they actually do a will that's properly written out and created in such a way that there is no cause for dispute in the future is what we should be doing, each of us.
Yes, yes.
True. Okay, that's good to know. I just had one more leading question into this. The will that we create in Canada, is it valid in other countries, let's say India or Pakistan or wherever, like, is that valid?
You can create an international will, but
Mm-hmm.
for that you have to go through consulate. So you have to register at consulate. Once the consulate, let's say Indian consulate, they notarize or they put their stamp on it saying that this is registered with us, you can take that will back home and then you can execute that will. Yes, you can do it, but the procedure is very long.
Mm-hmm.
Yep.
So I get it. Okay. So there will be the consulate involvement, and then you probably just take months and months to get things done.
Yes.
So then it is pertinent that you create a separate will for your assets in India and then you create a separate one for your assets here.
I would say that's the best option, because if the matter goes to litigation,
Right.
Canadian courts cannot decide on property in India. They
True.
don't have jurisdiction, right? Similarly, the Indian courts cannot decide for a property that is situated in Canada.
True.
So it's a better option to have two wills, one stating that this deals with the Canadian properties only, and the other with the Indian properties only. So that, I mean, in case of dispute,
I think we may have lost Madan for a little bit. So what we will do is we will just cap it here. And yes, this is so. Thank you so much for watching our channel this morning. And